Hey, everybody. Welcome to True Crime Wednesday. I'm Lori Hellis. For those of you who might be new to the channel, I am a retired criminal attorney who wrote a book about the Lori Vallow case. And we talk true crime here on all things true crime here on Wednesday evenings. So, welcome. Uh, Hope everyone is doing well tonight and things are going well here. Um, I'm working on a couple new projects that I'll be able to talk more about as time goes on, but I'm super excited about it. And in the meantime, we have a bit to talk about having to do with um, true crime. There are several cases that had some developments in it. You know, the time around the holidays in January are usually a little slow in the world of trials. Courthouses are usually pretty quiet this time of year. So, not surprising, but we have a few small developments to report. And so we can go over those. Lori Vallow, my friend, had a hearing in Arizona recently that I wanted to talk a little bit about. This was the first time, really, we'd had an opportunity to see Lori doing her own representation. Now, I have to say, I thought she did a pretty decent job. She does have standby counsel, so she does have lawyers to help her and advise her, but she presented her motions. Now, do I think her motions had any basis or had any chance that the judge was going to grant them? No, but I thought she did a pretty good job of arguing her side of the case. So let's talk a little bit about what her motions were. She did win one. She asked that the court change the heading on her case to reflect that her name is Daybell and not Vallow. The judge decided that because the case started with her as Vallow, that he would allow them to change the name on the case to Lori Daybell, formerly known or also known as Vallow. But he did give that little, uh, toss that little bone to her. It was also interesting that she was, as usual, wearing her hair tie wedding ring. So it appears that she is still all in on Chad Daybell. But I don't think that's a surprise to anybody who's followed the case for any period of time. So the other motions that she asked were a little more substantive and a little harder ask. First, she asked for the judge to give her all of the records of anything that has been gathered by the jail since she was moved from Idaho to Arizona. So she wanted all of the Maricopa County jail records. And the judge said, that's a lot of records. So, not just recorded phone calls or recordings but everything means every administrative note, every email, everything. And the judge said he thought her request was overly broad. Now, my understanding is that the reason she's looking for this information is because she believes that the jail recorded and then leaked conversations that she had with her attorneys that were protected by attorney client privilege. I don't know whether they did or not. We have seen in other cases, such as Murdoch, instances where um, a, a reporter put in a FOIA request and the jail released phone calls that were between Alec Murdoch and one of his lawyers. It was improper and it was a mistake, but they did release them. So it's hard to say at this point whether the jail has recorded attorney client privilege information that they have or have not released. But the judge said what she was asking for was far too broad. He did not foreclose the possibility of her resubmitting that request more narrowly. I think if she were to resubmit her request as a request for all uh, phone calls or all all in correspondence and recordings between her and her attorneys, those would be sort of reasonable parameters to put around that. But to just say I want every record created about me since I came into the Maricopa County Jail, that's a lot. I mean, it could be health records, it could be um, behavioral health records, it could be simply logs of visitor logs, it could be simply logs of when she was in and out of her cell. So it is a it encompasses a lot more information than just how many times her lawyers called her or what they said on those calls. So the judge didn't tell her you can't ask for this again. He just said what you're asking for is overly broad. Um, so the next thing she asked for were similarly records of conversations that were had during her extradition process. The judge denied that one, saying he didn't believe that there would be any relevant information in there. One of the things that she asked was as she was talking to the judge about ongoing discovery. And I understand what she's trying to get to, but I don't think she really understands. So what she said was she wanted the prosecution to provide her with whatever evidence they intended to use to prove there was a conspiracy. Because she said in the 10,000 pages of discovery, there is no evidence of a conspiracy. The judge said, you have received a transcript of the grand jury, haven't you? And Lori said, yes. And he said, well, that is the best indication of what it is that the state has to prove the conspiracy. He was attempting, without giving her legal advice, which he's precluded from doing, by sort of pointing her in the direction and saying, the transcript that you received of the grand jury proceedings was the evidence presented by the state to prove probable cause. So that would be the sort of a roadmap for her on where to look for that evidence. I think from the Idaho case, it's clear that that is the evidence of an actual agreement is going to be proven by the whole picture. If you'll remember in her Idaho case, we didn't come up with a smoking gun text message that said, tonight's the night we're going to kill Tammy, or tonight's the night we're going to kill Charles. We didn't come up with that. But what we came up with was a lot of circumstantial evidence that pointed to that conspiracy and that the state argued was proof of the conspiracy. So I think I think she's being, as is typical for her, she is being very literal, very black and white, very and so she's not really understanding that you can prove something by the totality of the circumstantial evidence, that you don't have to have the smoking gun text message. So she's saying, okay, produce the smoking gun text message. And so the judge said, um, so what she asked for was she wanted them, the state, to specifically produce evidence of the conspiracy. The judge said, you have all your discovery, you have everything the state has, presumably, and you have a copy of the grand jury transcript, which should sort of act as a roadmap for where the state is going. Um, she asked that they pare down their potential witness list to the people that they are actually going to call so that she can and her investigator can begin doing um, interviews and talking to some of these witnesses. She also complained, and this we saw in the Sarah Boone case as well when she was representing herself. There is a process when you send mail to an inmate, and it's not as simple as you slip it through the window and the clerk hands it to the inmate, because there's a great deal of contraband that comes into a jail, or is attempted to come into a jail. And for that reason, there is a whole process. So when mail comes in, that's why in the P. Diddy case and also in Corey Richard's case, there was some controversy about whether things were marked legal mail or legal correspondence. Because what happens is if I, as your defense lawyer, need to get discovery pages to you or something else to you, and I put it in an envelope, I have to make sure several things happen. I have to make sure there are no paper clips, no staples, no any kind of metal attachments to it. And I also have to make sure that the envelope doesn't have a metal clip on it or one of those little prong things or any of those things. And I have to leave it unsealed so that the jail staff can confirm that, in fact, it doesn't have any contraband in it. Now, they're not entitled to make copies of that or to keep it or to read it. And they're certainly not they can't disseminate it or share it with anybody. But they do have to have access to that envelope. Similarly, if something comes through the mail, when the postman delivers it, every one of those letters gets opened by jail staff, and jail staff pull the letters out. They make sure that they are not contraband, that they don't contain any untoward images or any information that shouldn't be passed on to the inmate for jail safety. Want to make that clear. They make sure that there is nothing illegal in the envelopes, and they make sure that there is nothing in that correspondence that would present a threat to the jail. So that takes some time, and the bigger the jail, the more time it takes. So, for example, Sarah Boone, it was taking 5 to 7 days for her to get her mail. Same for Lori Vallow in Maricopa County, which is a very large local jail, county jail. So she complained that she was having trouble getting things and was not getting things in a timely way. So she asked that the court direct the prosecutor to send things directly to her. Well, the prosecutor is sending things directly to her. Now, there is a filing system. So when a lawyer files a motion, there's an online portal that support staff or the lawyer goes in and they fill out an online form, and they attach a PDF of the pleading to it. And that's the way that filing is done these days. In the old days, we used to walk up with paper and hand it to the clerk through the window, and they'd stamp it and do all sorts of things, and then it would go off to be filed in the case file. Now all those case files are electronic. And in a lot of states, Oregon is one of them, the public can access those unless they are specifically in a sealed portion of court file. The public has access. You can go in and click, and everything is scanned into a PDF document that you can pull up. It's not that way in every state. In Idaho, they only post cases of interest, and then and they don't post everything. And in a lot of other states, they have not updated their systems yet. And so you can't go in and look at each document. But every one of them is now comes in through an electronic portal and is filed electronically. So, for example, the prosecution files a motion or the defense files a motion to suppress something. That's filed in the portal, and the service on all of the legal parties is done electronically. Well, if you are pro se, you don't have you don't have access to an email that you're going to get a notice that there's a new filing in your client's case. So she said, I don't want filings to go through the electronic system. I want them to come to, I don't want to be served by the electronic system. Well, the judge said, that's really the only system that we have. And the prosecutor said, I have been sending courtesy copies directly to her because I know that she doesn't have access to the electronic portal. The dilemma is that when they send her things by mail or even by courier, even if it's just dropped off, it's still going to take some time to work through the jail process before she actually physically gets handed the paperwork. And that is something that Sarah Boone ran into too. And it is definitely something the judge said he doesn't really have any control over. But he encouraged the jail to try and turn her mail around as quickly as possible so that she could get notice of hearings and what have you. The judge asked, the judge questioned her a bit about the relevance of some of the things that she was asking for, like the extradition records. And she came back with a pretty good answer. She said it's relevant for impeachment. Now, I don't know whether there's anything in her extradition in the records of any statements she made during her extradition that could, specifically from Idaho to Arizona, because she was extradited years ago from Hawaii to Idaho. But she's talking about the 2-day trip from Idaho to Arizona. So I don't know that she's going to get relevant information that way. I still think that one of the reasons why she was so adamant about representing herself is because she has gone to her lawyer. She went to her lawyers and she said, I want to go and make the case that I made in my conversations with my son and in my allocution. And that's that no one was murdered in Idaho. And I think her attorneys rightfully said that case has already been adjudicated. And it has no relevance to Charles Vallow's death because Charles Vallow's death happened before any of those happened. And there is absolutely no way a judge is going to let it in, and I'm not going to try and get it in. And I think that Lori is adamant that she wants her day in court actually making those arguments. And I think that is why she decided that she wanted to represent herself. Do I think a judge is going to let it in? Absolutely not, because it has no relevance to Charles Vallow's death. Charles Vallow died in July, and the first of the children's deaths didn't happen until Tylee in early September. JJ died later in September. Tammy Daybell was in October. So there's absolutely no relevance to it. But I think that is one of the reasons why she has been so adamant on representing herself, because she wants to be able to control that and to try and get that in. You know, I suppose there is an argument to be made that it is propensity evidence, that it's 403B evidence that goes to motive or to state of mind or whatever. But you cannot get around the fact that 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 that's like putting the cart in front of the horse. You can't come back and say what happened when Tylee and JJ and Tammy Daybell died. It goes to prove motive, or it goes to prove um, a course of conduct when it happened after Charles's death. So I don't think it comes in, but I do suspect that that's what she wants, and that's why she insisted on firing her lawyers. Now, we know that the conspiracy to murder Brandon Boudreaux is the first case on the docket. When Arizona filed these cases, because they happened at two different times and with two different victims, they originally filed the one against Brandon Boudreaux first, even though the attempt on his life came after Charles Vallow's death. They filed that one first, and they didn't file the charges in Charles Vallow's death until Idaho was pretty far along in the prosecution for Tylee and JJ and Tammy's deaths. So the case against Brandon Boudreaux, typically courts try the oldest case first. And so the Boudreaux case is the oldest case. So that one is going to go first. It is scheduled for March 31st. And I don't think this judge has any intention of delaying this trial at all. And she asked about, can I have a firm date on the second case? And he said, no, because we have to see where you are in the Boudreaux case first. That sort of says to me that the judge really does want to start the second trial pretty much as soon as the first one's over. So that one will go first. There is a pretrial conference on March 18th. There's a pretrial conference, just kind of a pre-scheduling conference for the trial, and I'm sure at that point they'll also be talking about jury selection. Now, the judge did ask about jury selection and having potential jurors fill out forms online, and Lori did say that she had consulted with her standby counsel and that they were going to help her with that, meaning that they will help her with access to those online questionnaires, I'm sure. There's no question that in this day and age, a pro se litigant that does not have access to electronic device, to a computer, to online resources, is at a real disadvantage. No question. So we saw that in Sarah Boone, and we will continue to see it anytime we have a pro se litigant. This judge did say he wasn't 100% sure that he was going to keep the case. The case would continue before him, but he thought that it would. The prosecution pointed out that his courtroom is fairly small and asked whether it would be possible to move it to a larger courtroom. The judge said that he would have that conversation with um, the court manager, and that he would let them know. One of the downfalls of his small courtroom is that there isn't a place for witnesses to wait until they're called. There isn't a place for victim families. We saw that in the Vallow case. Um, there is a waiting area, sort of like a conference room, right outside the courtroom doors, and that was available to be used by victims. They had family members that were there. They brought lunch to them there. They had other places where they could be sort of out of the press of the public and the press. So just want to make sure that I have got all my notes. I've been messing around with my lights, and while I think I don't look quite so much like the crypt keeper tonight, I'm having a little trouble reading my notes. So, and when I put them up on my screen, oh, thanks, Bo Pete. That's a good question. When I put my notes up on my screen, the glare is on my second screen. The glare is so terrible that I'm back to looking like the crypt keeper. So, um, she has asked for a speedy trial. Now, initially, the court set a speedy trial, and initially it was within that 6-month period. Now, early in the case in Arizona, and like every state's a little different in how they do speedy trial. In Arizona, a court can make a finding that this is a complex case and that there is good cause to extend the speedy trial window because of the complexity of the case. So early on in the case, when they initially were talking about time to get her to a preliminary hearing, or in, inevitably she waived a preliminary hearing, but when they were talking about that initially, the judge said, I'm going to make a finding that this is a complex case, that there's terabytes of discovery, and that it is so once the judge designated the case as a complex case, then what happened was that her initial attorneys withdrew, and she had a second group of attorneys. And they said to the judge, we literally have just gotten the discovery, and trial is next month. And the lawyer said, there's 10,000 pages of discovery, and I have been through about 6,000. And so the judge then said, because this is a complex case, I'm going to find there's good cause to extend it beyond the speedy trial window. But that would be the last continuance. So the fact that it is now set in March, it would now be bumping up against some constitutional claims if they would extend it any further. The judge has sort of pushed it as far as he could. We saw that in Idaho as well. Judge Boyce actually pushed her speedy trial window out by 41 days. And that's part of her appeal, is that they exceeded the speedy trial window by 41 days. So we will wait to see if that is one of the things that the Idaho Supreme Court finds is a basis for a new trial. So I think I don't think we're going to see an extension on her trial. So let's talk about some other cases. Um, Delphi, Richard Allen and Delphi continues to be in the news because the aftermath of the trial, if you recall, trial happened in November. He was found guilty. He was sentenced on the 20th of December. It was not until the 20th of December that the judge actually rescinded the gag order. The judge absolutely said she was not going to vacate the gag order until he was sentenced. So once that was done, she really didn't have any authority to continue the gag order. So that it wasn't until December 20th that the gag order was lifted, and that meant that some of the people who were involved in the case could now talk about it. And we have seen um, Andy Baldwin and Brad Rosie and Jen. Uh, I don't want to mispronounce her name. Anye, I believe her name is. It's a French pronunciation. Auger, Auger. Um, anyway, we have seen them now start uh, making some appearances on with some YouTube creators and with some media, including local media in Indiana and some national media as well. I think they've been on Court TV, and so we also have seen at least one juror speaking out, and so we are continuing to see OJ. That's right. Thanks, Tiff. Um, uh, and we're continuing to see news trickle out a little bit when it comes to what's going on with Richard Allen. The last I heard on one of those programs, um, Richard Allen is in the reception center for the prison, and it is likely that he is going to be sent back to the same prison where he was pre-trial and that was so detrimental to him. And it's very unfortunate because his mental health is pretty fragile. And Andy Baldwin said the Indiana prison system has a specific jail, prison that has a concentration on mental health. And I would have expected that he would go there, but he has not. So um, I the appeal has been noticed. What that means is that they give the appellate court notice that they intend to appeal. That preserves their appellate rights. And then what will happen is what happened in the Vallow case. It could take months to get a trial transcript, and because it was a lengthy and really complex trial. So it's going to take a while for the court, uh, the folks who create those transcripts to get a trial transcript done. Once they certify that the trial transcript is finished and has been filed and has been provided to everyone, then the appeals court will start giving them deadlines for when their opening brief has to be filed, when the reply brief has to be filed, and it will move along. Nothing is fast in the appeals world. Even if, and typically what happens is the appellate court gives the defense, you have until this date, you've got 30 days to file your opening brief. And then it gets close to the 30 days, and the defense says, well, there's all these volumes of discovery, and there's days and days and days of trial transcript, and we need more time. So then the court gives them another 30 days. Well, then that backs off the reply brief. And then when the reply brief is due, the state says, hey, we need more time too. And then they get an extra period of time. And that kind of goes along for a while. And then if they're going to have oral arguments in front of the court, that has to be scheduled. And there is a very finite number of those slots. And it sometimes takes up to a year to get a slot to argue in front of the court. So, unlike the US Supreme Court, the US Supreme Court picks the cases that they will hear and slots them into the time frame when they are in session. That is not the case with state courts. State courts have the option to AWOP, which is approved without opinion, affirmed without opinion. Sorry, and what that means is, let's say they appeal to the appeals court, and the appeals court says, yes, we agree that there was some sort of problem, and we think you should get a new trial. And then the other side then appeals to the state Supreme Court. The Supreme Court can say, we're going to affirm the lower court's ruling without writing an opinion. But they still have to consider whether there's a legal basis for them to do that. They can't just say, we're not going to hear it. The US Supreme Court can just say, we're not hearing that. We're not taking up that case with that issue. And the US Supreme Court really only takes up about, I don't know, maybe 1% of the cases that come before them. I used to know that number, and I can't pull it up right now, but it is a very small percentage of cases that actually get taken by the US Supreme Court and heard in full. So even if the state Supreme Court affirms the lower court's decision without writing a full opinion, they still have to consider the legal arguments and consider whether or not the lower court got it right. It's not just, we're not hearing that. It's, we looked at it and decided to affirm what the lower court did. Hopefully that makes sense. So all of that said, that appeals process is going to go on for a long, long time. And it's unfortunate because Richard Allen is not in great health. From all the indications we have from media is that he's mentally fragile and he's not in great physical health. So, it is going to be a difficult period for him to hang on until his appeals are heard. So, let's move on to Karen Reed. Not a whole lot going on in Karen Reed. Well, there was a whole lot going on in Karen Reed, actually. But it ended up being almost sort of like a footnote. If you recall, during Karen Reed's original trial, the defense was contacted by a woman who said, I'm an expert in dog bites. And when I look at these injuries on Richard Allen's arm, they look like injuries from a dog, both scratches and bite puncture. And it happened either during trial or imminently before trial. So they decided to call this woman. They interviewed her. They thought she was a really compelling witness. And so they decided to call her. And so during the first trial, they actually had to take a recess from the trial in front of the jury and have what's called a Daubert hearing. Now, you've all heard me talk about Daubert before. Daubert is anytime there's an expert and presenting any sort of scientific opinion, it has to meet certain criteria that are set out in the Daubert case. So they had a Daubert hearing as to Dr. Russell, who is the dog bite expert. She is incredibly qualified. I mean, where do you find somebody like this? She was a cop. She went to medical school, became an ER doctor. She's also a board certified forensic pathologist who's done autopsies. So she's seen dog bite cases both in autopsy as well as in the emergency room. She also worked for a major hospital that provided all of the hospital care for police officers, including police officers who were canine officers and who got bitten during trainings. And I mean, her qualifications are incredible. So after Karen, the jury was hung in the Reed trial, and the judge rescheduled the trial. The state brought in a new lawyer to add to their prosecution team. And he is literally going back through everything and he is redoing everything. And so, one of the things he wanted to do was he wanted to have yet another, he filed a motion in limine, meaning a evidentiary motion ahead of time, saying we want to keep her out because she's not an expert. She doesn't meet the Daubert criteria. So they had a 2-day Daubert hearing with Dr. Russell. And I'm telling you what, she was very, this is a woman who's had a lot of experience testifying between being an emergency room doctor and being a forensic pathologist. She's testified a lot. And she was cool as a cucumber on that stand. And she was eminently qualified, very professional. And the state, try as they could, as they might, could not ruffle her. She was very clear. And so, but one interesting thing that came out during the Daubert hearing was, if you recall, when this whole case was under investigation, the house where this John O'Keefe was found dead in the yard was another police officer, and they had adopted a German Shepherd who had washed out of canine training. So he was a canine university dropout. And as a lot of those dogs, they're trained to be very protective and pretty reactive. She wasn't a great family dog, and she wasn't great with strangers. So the homeowner testified that she was locked upstairs in his bedroom because of that, and that he would never have let her out among strangers, and that she never that he never that the dog was never out around all those people. So there's no way that she could have attacked John O'Keefe. Now, there's all this argument about whether or not John O'Keefe ever went into the house at 34 Fairview. Thank you, Tiff. And or whether the injuries happened outside the home. And they so during this second Daubert hearing for Dr. Russell, it came out that the prosecution initially, they couldn't find the dog, because conveniently, by the time that they were doing all these investigations, Chloe the dog had been rehomed to somebody in Vermont, I think. And so they said, "Oh, we can't find Chloe." Well, interestingly enough, it came out during the second Daubert hearing that they know where Chloe is, and in fact, since they've starting to get ready for the second trial, they actually have gone to where Chloe is, and they have taken molds of her teeth, and they have taken measurements of her claws and all of those things. So it was a little laughable because Judge Canoni, who really, she's tried pretty hard to, I would say she has given the state the benefit of the doubt at every turn. I'm not going to say that she is biased in favor of the state, of the prosecution, but I will say that she really has given them every benefit of the doubt. So it was interesting because her order says it was a close call, but I am going to find that Dr. Russell is an expert on dog bite injuries. I don't think it was a close call at all. I watched the hearings and I didn't think it was a close call at all. And I thought that Alan Jackson and his team did a great job, and they basically showed that she was eminently qualified. But Judge Canoni had to sort of make it sound like, oh, it was a close call, but yeah, I'm going to let her testify. So at that, and one of the things she said was, but she did find that Dr. Russell is an expert, but she also found that Dr. Russell had not compared the injuries to the actual dentation of the dog. Well, of course, now that the defense knows that the state has all that information, I'm certain that they're going to hand it all to Dr. Russell and say, Doc, what do you think? So that that will be an interesting development as we move forward. Um, the other significant development is that today, I believe, although it may have been yesterday, State Trooper Michael Proctor was facing his final disciplinary hearing about his behavior both on and off the job. So, if you remember, um, he he did some pretty untoward things. He sent out text messages that he was texting between he and his supervisors about Karen Reed. He texted that he was looking for nude photos in her phone. He texted with a group of high school and college buddies about the case, about the evidence in the case. And he was actually texting about evidence in the case some, I don't know, 12 hours after the case, the John O'Keefe had died. So, and making very misogynistic and nasty comments about Karen Reed, making rude, nasty comments about her defense attorneys, I mean, just very unprofessional and very unnecessary. And and of course, there are many questions about how the footage from the that was taken in the bay at Canton Police Department at the time that they brought Karen Reed's car in for examination, the state was already in charge of the investigation. They impounded her car, but they took it to the closest place where they had uh, a maintenance facility, and that was at the Canton PD. So they pull it into the Canton Police Department, and there are cameras, and they're motion activated cameras, and there's cameras recording, and they provide all that information to the defense, but they inverted the image. What that means is that although it appears that they are standing next to what would have been the tail light that was broken, that supposedly was broken by contact with John O'Keefe, because the image is inverted, they were actually on the other side of the car. And it was very, very misleading. So from everything we can tell, um, it was that way when Proctor dropped it off at the Canton Police Department, the video. So it's going to be interesting because he's now damaged goods. He was the lead investigator on the case. And it's not going to take anything at all for them to start going after the investigation. Well, if the lead investigator was dirty, if the lead investigator was making uh, was manipulating evidence, what can we say about how they were manipulating evidence? Anybody else was manipulating evidence. So it's a huge black eye for them, and it's a huge dent in their case. So thank you, Jill, for the comment. Free Chloe. Apparently, Chloe is living with another family who are better able to take care of her and is happily living out on a farm somewhere, supposedly. So that's what we know right now about Karen Reed. We also know that as those hearings were happening, and the judge was hearing the Daubert hearing, the prosecution filed motions in limine to keep out both of the experts, the bioengineer and the accident reconstructionist that were hired by the FBI. So, in the process of this case, all of these concerns came up about Canton PD and uh, the Massachusetts State Police, almost said Indiana, Massachusetts State Police and Proctor. And they were all under investigation. Well, who investigates law enforcement? The FBI. So the FBI was investigating them. And as part of their investigation, they employed their own accident reconstructionist and their own biophysical engineer, biophysics, having to do with the body. And they testified at trial. Well, they utterly demolished the state's witnesses. The state had one guy who was sort of half-assed trained in accident reconstruction. Now, basically what this is they take all these different measurements, all these specific measurements, and they plug them into a computer program, and AI basically tells them what happened. This is not something where this guy's sitting there with a calculator or a slide rule trying to figure out what really happened and what the impact and all of that is. He didn't have those kind of capabilities. But the scientists, the PhD scientists that the FBI hired, did. And they utterly demolished the state's case. So now the state wants to keep them out. And I don't know how the state's going to keep them out, but they're going to try. And if Judge Canoni can bend over backwards to help them out, she just might. So we'll see. But for now, we're going to be looking for some. I expect that we're going to see a number of hearings, probably one kind of omnibus motion hearing where they're going to hear all the motions at once. There are going to be motions about the data that came from Karen Reed's car was going to be reanalyzed. There were some motions having to do with phone records. So we're going to hear all those motions. They're going to come up, and they need to come up pretty quickly because her trial starts the 1st of April, and Judge Canoni has been pretty adamant that she does not want to continue it. So she gave them a continuance. The state asked for a continuance when they brought the new guy on, and he wanted to go back and retest everything and redo everything. And so she extended it from January to April. She's not going to extend it again. There would have to be an earthquake in Massachusetts for her to do that. So we'll be watching to see, because I think those pretrial hearings are going to have to come up pretty soon in order to get that out of the way before April. Donna Adelson would like to have her trial moved out of Tallahassee. I bet she would, especially when it comes to light all of the uncomplimentary things she had to say about Tallahassee and how stupid people in Tallahassee are. I think it goes nowhere. First of all, it's not timely. And second of all, in Florida, they actually have to try and seat a jury and be unable to seat a jury before they will allow a change of venue. So I don't expect that she's going to get a change of venue. The other really interesting thing is that they've had a closed door hearing having to do with Robert Adelson. He's the kid you don't hear much about. He's Harvey and Donna's eldest son. He's a medical doctor. And he had a falling out with the family um, years ago. When he was a resident, I believe, he met a woman who was not only not Jewish, but she was Indian and Hindu, I believe. And Donna Adelson just could not cotton the idea that he was going to marry or be serious about someone who was not Jewish. And he then broke off his relationship with the woman, married a Jewish woman. It was a very short-lived marriage, which he later said was incredibly unfair to the woman he married. Um, and he reconnected with his true love, and they got married. Donna and Harvey attended the wedding and sort of made nice, but he's very estranged from the family. Well, the defense took his deposition, and the state wants to keep it out. We don't know what he said because all of that was done in an in-camera hearing, but it is kind of intriguing that did Donna say something to him on the phone? We know a couple of things that have come out in court. One is that it is alleged that Rob said, there's no one who puts their interests first more than my mother. So there's nobody who looks out for themselves first more than Donna Adelson. The other thing is that there is some sort of a report or some Rob tells a story about an incident that happened where Donna and Harvey used a racial slur, presumably against his wife. So if that's the case, that can come in to show bias. And that can come in for purposes of showing motive or bias, even though it couldn't come in, even though it might be hearsay and it couldn't come in to prove that Donna's a bad person, but it could come in to show that she has a bias against people of a different race. I don't know how that's relevant, particularly because Dan Markel was a nice white Jewish boy. But the people who were involved in the murder, the gunman and Katie Magbanawa, were all Hispanic. So I don't know where that, if it's relevant and whether it comes in at all, but it has been, it's out there that Rob tells some sort of a story like that. I wanted to give you a little bit of an update on James Craig, but I don't know anything. I've been trying to find out. He was scheduled to start a preliminary hearing yesterday, but there is absolutely nothing out there. There's no reporting, there's nothing. So it makes me believe he's the Colorado dentist who is accused of poisoning his wife. He also has been charged with witness tampering and with soliciting an inmate to murder a detective. So he's in a lot of hot water. And but I haven't heard anything about the results of that. Couldn't find it on in the court's portal. I couldn't find it at all. So when we find out something about, so I'm kind of suspecting maybe it didn't happen, but I don't know. But when we find out, I'll let you know. There were a couple of other interesting things that I wanted to bring to your attention. One is there's a new case. It's not one that's been high on anyone's radar, but it is one that Gigi from Pretty Lies and Alibis is covering because it is going on in her hometown in Greenville, South Carolina. And it is a really convoluted and kind of fascinating case, and it's got a lot of it's got a lot of sort of salacious pieces to it, and that is they're calling it the rose petal case because rose petals were scattered, I think, around her body. But her name is Christina Parcell, Parcell, Christina Parcell. And her trial was supposed to start day before yesterday, and apparently they didn't get enough jurors. And so they have postponed it. And Gigi had said she was going to cover it live. She was going to be in the courtroom, and that she wasn't sure, but she thought perhaps Law and Crime or Court TV could be streaming it. So um, definitely keep an eye on Gigi's feed because that looks like it'll be worth watching. Let's put it that way. It's a pretty salacious case, and another one that also involves or potentially involves child custody, similar to Shanna Gardner. So, and lastly, I wanted to talk just a little bit about Alec Baldwin, although it's not a criminal case anymore. So recently, as you may recall, Alec Baldwin was on trial for negligent homicide for discharging a gun on the set of a movie called Rust. And he believed that that the gun was loaded with dummy rounds. Now, dummy rounds are not even blanks. They're just inert rounds that are put in the gun for the camera. So in a gun that has a cylinder, you can always see a bullet. And so in order to make it look real, they put a dummy round in there. So the gun was loaded with what he thought were dummy rounds. Those are inert. If you pull the trigger, nothing happens. Now, if you have a blank has gunpowder, so it explodes, it makes a bang, but it has no projectile, so nothing comes out of the barrel of the gun. So in this case, he believed they were dummy rounds. When he was blocking the scene, they were practicing blocking the scene. He either put his finger on the trigger or didn't, depending on whose story you believe. But the gun discharged and it shot two people. A single bullet went through both people. One was injured and one died at the hospital shortly after the accident. The armorer on the scene was found guilty of negligent homicide, as should have been the case, because she was ultimately responsible for making sure that that gun was safe. However, they also went after Alec Baldwin. They had a lengthy trial. They were almost to the end of the trial. Special prosecutor Carrie Morrissey was heading up the trial. And she was a really unpleasant person. She was unpleasant in the courtroom. She was dismissive. She just really was not a nice person, not professional. Toward the end of the trial, it came out that the state, Carrie Morrissey, had hidden or overlooked, depending on whose version you believe, crucial evidence in the form of rounds that looked like the dummy rounds and were live. So there was a lot of discussion in there about what the dummy rounds looked like. The dummy rounds had a certain kind of color of where the primer would be. They had a certain, and there was all this discussion about some looked like this, some looked like that, some had brass primers, some had silver primers, and ultimately there were a handful of live rounds that looked the same, had the same configuration, the same colored primers as the dummy rounds. And that was either overlooked or hidden, depending on who you believe. And the judge found that that was enough of an egregious withholding of crucial evidence that she declared a mistrial and dismissed the case with prejudice, meaning it can never be brought again. And so Carrie Morrissey, since that time, even though the judge issued this very well reasoned written opinion about why she was dismissing the case, Carrie Morrissey has been trying to get that decision reversed ever since. So she went back to the judge and said, please reconsider your decision. And the judge said, talk to the hand. Then she said, please, 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 pretty please, overrule your decision, not to overrule my motion. And the judge said, talk to the hand. So Carrie Morrissey filed an appeal with the appellate court, asking the appellate court to overrule this judge's dismissal of the case. And she was just adamant that she was going to go forward, go forward, go forward. She was unpleasant and argumentative when she was called to task for the whole issue, and very unrepentant. And so she's just been adamant, we didn't do anything wrong. We didn't, it wasn't wrong. And so what has happened, if you read between the lines, Carrie Morrissey filed a motion to withdraw her appeal of the judge's ruling dismissing the case. And reading sort of between the lines on that, you could see that I want to be cognizant tonight that we do need to wrap up right on time, because Jen needs to make an airport run. And so I just want to make sure that we end a little bit early tonight so that we can get Jen on her way. And I just saw her behind the scenes and thought I better mention that. Anyway, so Carrie Morrissey has withdrawn her appeal of the judge's rulings. This is very clearly because her boss, the elected DA, has told her, we're not going to pursue this appeal. And she does not have the authority. It's only the DA can appeal. She doesn't have any legal standing to appeal unless the DA does. So she has withdrawn her motion. But in characteristic style, instead of just saying, as one normally would, here is my one paragraph motion, please dismiss, I'm withdrawing my motion for appeal, please dismiss it. Instead of doing that, she went on for 8 pages, all about the reasons why the appeal was well taken, and she was within her rights to make that appeal, and all the reasons why it should have been appealed and how she was right. But oh, by the way, I'm withdrawing it because the DA says I have to, basically. So she is just not going to give an inch. And it was kind of comical. Then, very quickly on the heels of that, Alec Baldwin has now filed a civil suit for wrongful prosecution and I think defamation and some other things as well. So he's now brought a civil suit against the officials in New Mexico, including Carrie Morrissey and including the elected district attorney and everybody else that was involved. So That is the case is going to keep on giving for a very long time, as is the Jay-Z P. Diddy stuff. Um, it, that one's interesting. I'm not even going to go there. There are folks, Emily D. Baker's doing a great job of keeping up on that one. There are other folks that are much more into the pop culture and the civil cases. And, they can, I'm counting on them to keep us advised of that. Of course, there are criminal cases that do go along with those. P. Diddy's been charged uh, in a whole bunch of charges, but we'll wait to see how that all shakes out. So that's all I have for this evening, but I'm ready to take some questions. While we ramp up questions, I want to just give everybody a couple of heads up. I'm going to be making a couple of appearances in March. And y'all want to get those on your calendar. We'll put the dates in the show notes and circulate them in the community tab. But I'm going to be at the Tucson Festival of Books at the University of Arizona in Tucson on March 13th and 14th, or 14th and 15th, I think, whatever that Saturday and Sunday is. I'm going to be on two different panels with other true crime authors talking about true crime, writing it, researching it, doing all that stuff about the stories. And then I'm also going to be doing a book signing in Phoenix. So if you happen to be in Phoenix, I'm going to be going from Tucson to Phoenix for a book signing, and we'll get all that information out to you. And then on the 25th of March, I'm going to be in Boise at Rediscovered Books doing a book signing there. And I'm going to have a co-panelist who is a woman who wrote a book about the Polly Klaas case. So it should be really interesting. And we'll get all that information out. And then I'm also going to be going to McCall, Idaho to do a book signing there. So if you're in McCall, Boise, Tucson, or Phoenix, or anywhere in the area, come and see me. I love meeting people. And it's always so much fun when somebody walks up and goes, "You're the good Lori, I know you." It's great. So please consider that. Book stuff's been going really well. That's the next thing I wanted to talk about, Ronnie. I have I have some quilt squares for the quilt for Kay and Larry. Tomorrow, no, Friday is going to be my day to really get into my sewing room and get it organized and be able to get some work done on that. So I need to make some squares, and also we could use more. If you are interested in making a quilt square, they are foundation pieced. It's pretty easy to do, and you can find the link in our show notes to the pattern on my Google Drive. So if you go and click on that link, you can get to my Google Drive and get in there and download the and print off the pattern. It is, and you can mail those quilt squares back to me at my PO box address. So the quilt squares require that you piece on a foundation piece of paper, and but it's real easy. It's kind of like paint by numbers. So they're really easy to do. Please use any color fabric for it. They look like an origami crane. So please use any color and any pattern of fabric that you like for the crane and put them on a black background. And that's the only requirement. And they need to be 6 inches. So, and if you have questions, drop them to me in my email and I would be happy to answer them. I have to admit that as of recently, with the holidays, I have not been all that great at going through the YouTube comments, but I am going to do that. And so I will be going through them, but I've been remiss in spending time going through them. So for all of you, please like and subscribe. Please like and subscribe. Share it with your friends. If you find the content interesting, share it with your friends. We've been hovering right about 8,000 subscribers. Um, since the Vallow case has been over, folks have been sort of going to find other things to watch, but please, because it does help people find us when you like and subscribe. Um, Hi, Don Shackelford. It's okay. I'm happy to see you, even though you're late. You're here. So, um, you got questions? This is a good question. Mac, should Melanie Gibb be afraid of being questioned by Lori at the Arizona trial because of how she testified in Lori's Idaho trial? Well, I think that could be interesting, and I hadn't thought about that before, but that may be one of the reasons why Lori really wants to be her own attorney because she wants to be able to ask questions of Melanie and Zulema. That could be worth the price of admission. Um, I will say that the judge is not going to allow Lori to go after them. She's certainly going to allow Lori to say, well, you testified at my Idaho trial this. Are you changing your story now? Was that a lie? Is this true? All of those things are very proper impeachment. So that would be appropriate. But she's not going to let Lori go after them and try and make them look bad or try and get one up on them or try and just use questions to discredit them or make them look bad. And Lori's in many ways the ultimate high school mean girl. So I think if she thinks that she can get away with um, demeaning them or getting her pound of flesh, she might try. But I think this judge is going to be very respectful of her and her right to represent herself. But he is not going to he's not going to give her a lot of leeway outside of what he would expect a licensed attorney to do. So he's not going to let her behave inappropriately. So, but that's a really good question. And that, bring your popcorn for that one. Hi, Mary. Didn't Canton PD also handle the Sandra Birch case? Yes, ma'am, they did. And Michael Proctor was the lead investigator. So all of these smaller suburban public police departments are all outside of Boston. So John O'Keefe was a Boston cop, but he was friendly with all the cops in these, particularly in Canton where he lived. And police go back and forth between agencies. So maybe they start out at Canton and then they go to Boston, or they start out at, in the sheriff's office and then they go to the PD and then they go to city police, or so they move around a bit. So he knew them all. What happened in the Sandra Birch case is that the Sandra Birch case is a case where a young woman who was an explorer scout and was interested in being a law enforcement officer, and a lot of law enforcement, fire departments, those kind of groups have explorer posts, where it's sort of like scouting, but it is focused on for kids who really want to be in that career. So she began. There are varying reports of when she became started with the explorers at the police department in Stoughton, which is again a neighboring community. So she started in the Explorer Scouts, and it appears that the offending officer started grooming her right away. By the time she was 15, he was having an affair with her. He was having a relationship with her. And that continued until she was 23. And at 23, he was married. um, she discovered she was pregnant, and she was adamant that he was going to be involved in this child's life. And she was found in a situation that was staged to look like she had taken her own life. Um, but medical examiners said that was not the case. It was staged. She was strangled. And the police officer was arrested. Well, because he was a police officer and she was an explorer scout, clearly the Stoughton PD could not investigate that case. So they brought in, it's very common for this to happen, they brought in investigators from Canton. So the detectives from Canton, who also were involved in Karen Reed's case, were investigating, along with the state police, Michael Proctor, that they were investigating Sandra Birchmore's uh, death. And some indication that they were not all that thorough because they didn't really want to cast a bad light and suspicion on a fellow officer. It's a good old boy community. Um, in addition, Michael Proctor was also the lead investigator on the Brian and Anna Walsh case. That's a case where Brian Walsh has been accused of murdering his wife, Anna. Her body's never been found. And he is awaiting trial, and I don't know that any a trial has been scheduled anytime soon. But what's interesting, and I think what Mary's trying to point out, is that in these cases, the misconduct in one of those police departments is being brought in to prove that the evidence that they can't be trusted with the evidence they gathered in other cases. So, for example, they're saying Michael Proctor was dishonest and unprofessional when it came to Karen Reed. So necessarily, his investigation, he must have been pulling the same sort of shenanigans in all of his other cases that he's investigated. And it really is casting a shadow on all of those cases. And the state is going to have to figure out how to deal with that. The district attorneys in the varying commonwealths, I think they're townships there, are going to have to figure out how to deal with that black eye when it comes to their investigation, because it's going to be really easy for the defense in, say, Birchmore's case to say, yes, but he did all of this hanky panky in Canton to try and protect Canton police and a Boston police officer. What's to say he also didn't do all this hanky panky to protect the Stoughton police officers? So they've got an uphill battle. It's going to be messy to try and get that evidence in. And with Karen Reed's trial being scheduled, the first part on April Fool's Day, it's coming right up. They're going to have to figure out how they're going to confront that. And I don't think there certainly isn't any way that they're going to be able to say, oh, let's just pretend that Proctor wasn't involved. We just won't call him as a witness, and we'll just pretend he wasn't involved. There's no way the defense is going to let that happen. They'll call him. And in fact, that happened in the first trial. In the first trial, there was already all of this information about all of these terrible text messages and all this stuff. He wasn't under investigation. He hadn't been fired, which lends huge credence to the allegations that he was dirty. But the defense was already saying, well, we want this guy. And originally the state was saying, well, we might not call him. And Ajax said, Alan Jackson said, if you don't, we are. And do you really want to not control that narrative? Because if we call him and we do the direct, you're not going to like it. Um, so they were sort of boxed into a corner, and they had to call Proctor, and they had to subject him to cross examination. I don't think there's any way they're going to get away with not testifying in the Reed case, but everything he's done is now suspect, and there's a little black cloud hanging over everything with his name on it. So that's what happens when cops go bad. Sarah Lennox, answer to your oral Supreme Court appeals, fewer than 100 annually. Thank you. Thanks for that information. Yeah, I knew it was under 100. The percentage is really small because there are thousands of appeals that get where their appeals are funny. In federal court, in order for you to appeal to the US Supreme Court, you have to identify a federal issue. It's not enough to just say, I'm not happy with the decision I got at the state, and I'm not happy with the decision I got from the state Supreme Court. I want to go higher. That's not enough. You have to identify a federal issue, an issue that the federal Supreme Court has jurisdiction to decide. So that's the first hurdle, is you have to have a federal issue. And then the next hurdle is that they have to grant certiorari, meaning they have to agree to take the case. And they're very picky. And oftentimes they sit down ahead of time and they say, these are the kind of generalized area that we would like to focus on for this term. So this term, we're going to talk about voting rights, or this term, we're going to talk about commercial rights, whether, the restraint of trade, or this term, we really, we sometimes it's things that people come to the individual judges with. Sometimes it's things that trends they see in lower court rulings, but they have the ability to sort of chart how they're going to navigate their session. So when they're in session, they may say, well, now that doesn't keep them from saying, having, their aides, their clerks read all of these petitions. It doesn't stop them. The aide from the clerk, my brain's getting addled, from bringing to their justice a particular case and saying, this is a really interesting or important issue, or this is something that hasn't ever been decided. It's a novel issue. So how about if, is this something that you think you would like to take to the panel and see whether or not they want to accept cert on it? But often they go into a session with sort of a general map of where they want to go, where they want to focus. So is it criminal search and seizure rights, or is it trade rights, or is it commercial banking? I mean, there are hundreds of areas that they are asked to take cases on. It's not just criminal law by any means. They're asked to take cases anywhere that anyone can identify a federal issue. So, and the U.S. Constitution covers trade and religion and right to privacy and a whole lot of other things besides Fourth, Fifth, and Sixth Amendment criminal search and seizure, right to counsel, those sorts of things. So, it will be, it's hard to know what the Supreme Court is going to focus on or what case they're going to take. But as has been pointed out, they take about 100 cases a year, sometimes fewer than 100. and those are spread out over all of those sort of different areas of the law. And that is out of thousands and probably tens of thousands of cases that are actually submitted for consideration. And those poor clerks are the ones who are going through them trying to see whether or not there are issues that their particular justice is interested in, or that the panels have said they're interested in, or something that presents a novel argument or a novel issue that hasn't been presented before. So, oh, hi, Rachel. The most interesting thing I saw in the Karen Reed case was that the prosecution name dropped Kenny Kinsey, uh, uh, presumably from the Murdaugh trial. Yes, Dr. Kinsey has been a popular guy since the Murdaugh trial. And it wouldn't surprise me at all if they were interested in bringing him in. He is a really good accident reconstructionist, crime scene reconstructionist, rather. He's not an accident reconstructionist. Let's be clear. He's a crime scene reconstructionist. So he could stand back and say, based on this crime scene, here's what I see the trajectory of the gun was, or where it was fired from, those sorts of things. But where the biomechanical engineer can actually talk about the injuries that John O'Keefe suffered and whether or not a vehicle could possibly cause that damage. So, I mean, they're different disciplines. They're related, but different disciplines. I don't know whether Dr. Kinney or Dr. Kinsey, Kenny Kinsey, um, uh, is qualified for vehicle reconstruction. I know that the FBI expert specifically was qualified to do vehicle accident reconstruction. So we'll wait to see. But he's a great witness. I mean, I don't blame him for calling him. He was great at the Murdaugh trial, and he really, I think, in a lot of ways, he really made the state's case in the Murdaugh trial. So good questions and comments tonight. Mm. Hi, Rachel. Can or will Lori call Chad as a witness? I'm assuming she will. I think she's going to try, because I think that that's the only way she really gets to see him face to face and they get to any time together. I think she's going to try. I suspect that his appellate lawyers are going to say he's going to claim the fifth, and won't testify, because that certainly would be my advice. That's what we're seeing in Adelson right now, is that Charlie Adelson's appellate lawyers are telling him, oh, hell no, you don't need to testify under oath. You know, right now, what they have, an appeal, is based on the snapshot of the trial. You know, it's like a Polaroid of the trial. But if you then testify under oath in some other setting, that could jeopardize the arguments that you have in your appeals, particularly if you go and say something different under oath in a different trial. Now, Chad didn't testify in his trial, but had to stop for a minute there. He didn't testify, but is still, you know, if you're trying to do an appeal, you don't want this guy to go on the testify. And because he still has a pending appeal, he's still got Fifth Amendment rights. So, yeah, I would be very surprised. I would be surprised if she doesn't try and get him there, but I would be very surprised if he actually does. So, Good questions tonight, guys. I don't recall. That's always the right answer. Would you consider making a video of yourself making a quilt square for those of us who are clueless about quilting? I would. I did some videos early on when we were doing the sampler quilt on how to make those squares. And when we started to do the paper piece project, I was really right in the throes of finishing the book, and I didn't really have time to make a video. There was a video, is a video, which I think is still linked in our show notes, of the person who designed the quilt square making the square. But I would be happy to do that. Now that I have a little bit more time, I will do that. So I'll try and do that in the next couple weeks. It's pretty straightforward, but it's always better to have an example. If you really want to do something right away before I'm able to do that, look up a YouTube how-to on foundation piecing, and that or paper piecing, it's also called, and that can give you a guideline. But I'm telling you what, if it's something you haven't done before, I'm warning you, you might get hooked on it because it's very easy and your seams are very precise because you're actually sewing on a pattern on a line. So let's take a couple last questions and wrap up for the evening so we can get Jen out to her airport pickup. Hi, Carolyn. What impression could Lori give to the jury when she represents herself? And how can she leave herself open to answers she doesn't want from witnesses? See, this is the danger of representing yourself. You don't necessarily know all the rules of evidence. And you also put yourself in a very uncomfortable position because you jeopardize your own right not to incriminate yourself. So she's got to be very careful as she is asking questions that she is not also testifying or putting information on the record that comes from her, because it's really a tightrope. It's really it's a tough dance to do, and she's doing okay, but I don't know if she's up to that. And I think there's a huge danger that in asking questions, she's going to open herself up to as if she had testified. She can call herself as a witness and give a narrative the way that what's his name in Las Vegas did. There's no, she makes that decision. I think that she understands that she should not testify, but she's also narcissistic. So I don't know. I don't know whether she will be able to. I don't know whether she'll be able to overcome that temptation, uh, not to tell her side of the story. So. But it's definitely a danger when you have a witness on the stand and you're asking that witness questions and they have questions that have to do with what that person said to you or what you did or what that person did. I think there's a real danger in in giving away information that could be argued is testimonial. So, one last question. Anybody got one? Hi, Jacqueline. Yeah, we pointed this out earlier. She wears a scrunchie, a ponytail holder on her finger in place of a wedding band. She's been doing that for a long time. She was doing it in Idaho. In fact, she was doing it in Rexburg before her trial was moved. So she's been doing it a long time. She's been really adamant from the very beginning that she is Chad Daybell's wife. She wants to be called Lori Daybell. She's pretty adamant about that. And in the hearing that was held this week, one of the things she asked the judge was to change the heading on the indictment uh, that identifies her as Lori Vallow to Lori Daybell. He did agree to do that with a notation that it will be Lori Daybell, also known as Vallow. But that's she is all in on Chad. She just has not given that up at all, and that's been going on a long time. So good observing. I observed as well. Tiff Knox, where is Trisha the trucker? I don't know, Trisha the trucker. Where are you? We haven't heard from you in a while, so let us know where you are and what you're up to. We miss you. So, good question. Judy Berlin, do you think maybe Lori is going to blame Tylee for the murder of Charles? You know, I don't know. I don't know because she's already got a scapegoat in Alex Cox, and he's not here to defend himself. And very clearly, if you have seen any of his police interviews, he very clearly says, "I shot him. I did it because he provoked me, and it was in self-defense." But he very clearly admits to being the guy that pulled the trigger. So I don't know what value there would be in her trying to make it seem like Tylee did that. I mean, it's bad enough at this point that she is claiming that Tylee um, accidentally killed JJ and then took her own life. I mean, that's bad enough. That's awful. But and I don't know how she would be able to make that fit with the facts as we know them. I mean, we've seen the police reports and the police interviews, the interviews she gave to the police at the time of the incident, So I don't I wouldn't put it past her. I mean, I think she'll try anything, but I don't know how intellectually she can make those pieces fit in a way that even she could torture into making that argument, if that makes sense. So, yeah, I wouldn't put it past her, but I just don't think I don't think that she gets there to the point where she can make that argument to a jury and have a jury believe her. So, well, folks, let's wrap it up. I want to get Jen on her way to her airport run. And I just want to say thanks so much for all of you being here tonight. It's great to see you all in the chat. And I promise, I will be reading comments and reading YouTube comments as well. So I'm going to say goodnight. Jen, safe driving, safe travel. She's got to go to LA Airport, which is always a little bit of a nightmare. So be safe. As always, Jen, thank you for your help. Thank you all for being here. I will see you next Wednesday, same time for True Crime Wednesday. Thanks.